What happens in Singapore is that the party who wishes to commence an arbitration will file a notice of arbitration and serve the notice on the other party. Usually, the arbitrator can be appointed by an agreement between both parties or by way of the International Center deciding who is going to be the arbitrator. But generally, normally the terms of appointment of the arbitrator will be stated in the contract, or parties can come to an agreement. If there's no agreement, the International Arbitration Center will decide. Once an arbitrator is appointed, the tribunal is constituted. There can either be one or three arbitrators. You will want to have an odd number because you don't want a situation where there's an even number and two arbitrators take a different position. After the tribunal is constituted, usually there will be a preliminary meeting where parties and the tribunal meet to discuss and agree on how the process is going to move forward and the timetable. You will notice straight away that in an arbitration is quite different from court in the sense that it's supposed to be more amicable. Parties are supposed to come to agreements on how they want to move the arbitration forward, what are the appropriate what's the appropriate timetable, what is the appropriate process, and sometimes if it's not provided for, what would be the appropriate rules governing the arbitration, and what would be the governing rules in relation to how evidence is presented during the arbitration. The claimant then will set out a summary of the matters in dispute, as well as what is the remedy sought. The respondent to the arbitration, that is the person who is the defendant, will then file a notice saying which parts of the claim he admits to and which parts he denies. He can also bring a counterclaim. After the statement of response is filed, you have the disclosure of documents and inspection of each other's documents. The next step, once documents are disclosed and all relevant documents are with each party, usually there will be written statements prepared. The written statements are in relation to all witnesses which each side wants to call. The plaintiff may have 2 or 3 factual witnesses, an expert. Likewise, the defendant may have 2 or 3 factual witnesses and an expert. All the witnesses will give statements and these will be exchanged. Thereafter, there will be a hearing before the arbitration tribunal and the tribunal will render an award. Now, today we want to place a bit or focus on something which was introduced to the Singapore International Arbitration Center in 2010, which is the expedited procedure. This is a time and cost-saving option which is available in an appropriate case to parties who want the matter to move along quickly under the SIAC rules. There are some limitations as to which kind of cases would qualify, and we will deal with that later. But before we do so, what I will deal with first is to set out, in summary, some of the rules which govern an expedited arbitration. These rules are found in the SIAC rule book, in particular Rule 5.2, which says the registrar, meaning the registrar of the SIAC, may abbreviate, that is, shorten any timelines under these rules. The case will be referred to only one arbitrator unless the president of the SIAC determines that there should be more than one arbitrator. And the tribunal may, in consultation with parties, decide if the arbitration should be decided only on documents, that is, there is no cross-examination of witnesses, or whether there is a need for a full hearing where factual witnesses, the expert witnesses are cross-examined, and perhaps even oral arguments on the law and the effect of the evidence which came out during the hearing is determined. Now, under these rules, the final award must be made within 6 months from the date when the tribunal is constituted, unless in exceptional circumstances, the registrar extends the time for making of such a final award. So you can see that this benefits parties who want a very quick decision. The decision has to be rendered within 6 months of the arbitration starting. And the award which is going to be given by the tribunal, you will know that usually in court or in common law countries or in arbitration, the tribunal will state in a very long judgment why they rule for either the claimant or the respondent. But in this case where you have expedited procedure, there is no long award given, but rather the tribunal will state its reasons. It cannot not state its reasons, it must state its reasons, but the reasons will be based in a summary form, unless of course both parties, which I think would be quite rare, have agreed that there's no need for the tribunal to give reasons. They can just make the decision as to whether the claimant wins or the respondent is successful in the defense. That ends my overview of the expedited procedure. My colleague Hamza will now speak a little bit more about the details in relation to this expedited procedure.
Hello, everyone. Just to double check, you can hear me as well. Okay, great. Yes, as Mr. Thuraisingam was saying, I am going to go through the rules he just laid out in a little more detail so you can get a flavor of how the expedited procedure works in practice. The first thing to note is that the default position is that there will always be, there will most of the time be one arbitrator. The president of SIAC has the discretion to decide otherwise, but generally speaking, in an expedited procedure situation, there will only be one arbitrator, not 3. The second key feature to notice is that under the expedited procedure, the tribunal has full discretion to decide whether a hearing should take place or whether the arbitration can be decided only on documents. This is different from the position under a normal arbitration under the SIAC rules, where if a party requests a hearing, the tribunal has to grant a hearing. Moreover, under the expedited procedure, the tribunal can decide whether to hold or whether to dispense with a hearing during the course of the arbitration. It doesn't have to decide it right at the beginning. A third key feature to notice about the hearings is that there's no limit, even though the arbitration has to be concluded within 6 months. There's no limit to the length of the hearings. They typically last between 1 to 2 days. If necessary, the tribunal can lengthen the 6-month time frame by a few days to accommodate a slightly longer hearing. Furthermore, the tribunal has to respect the 6-month timeline alongside trying to give each party a fair chance to have their arguments heard. So what that means in practice is that the tribunal can potentially not allow a party to introduce claims that during the course of an expedited arbitration, because it will delay the 6-month timeline. It could potentially not allow a party to make too many requests for documentary evidence of the other party, because again, it will delay the 6-month timeline. And another way is that it can combine two of the separate steps of a traditional arbitration under the SIAC rules into one. So for example, normally the written claim starts, and then down the line, there's document requests for evidence followed by witness statements. The tribunal can decide to combine it, combine the written claim with the witness statements in a memorial style, which is not exclusive to expedited procedures, but perhaps more common to them. There's a fourth key feature of the rules that Mr. Thuraisingam was discussing that you should take note of, which is that the expedited procedure rules can overrule contrary terms in the arbitration agreement of parties. In Singapore, this has been discussed, admittedly only in the context of an agreement as to the number of arbitrators. There was a particular case where parties had an arbitration agreement that agreed that there would be 3 arbitrators. During the arbitration, one party applied for the expedited procedure and 1 arbitrator was appointed. The other party appealed to the Singapore High Court on the basis of the arbitration agreement providing for 3 arbitrators. And the Singapore Court of Appeal decided that despite that, 1 arbitrator could still be appointed. Their reasoning was that the parties had agreed to arbitrate according to the SIAC rules, which incorporated the expedited procedure providing for 1 arbitrator, and their dispute was of a relatively small value. So it would be odd to not allow them to simply appoint 1 arbitrator and follow the expedited procedure. So this is something to take note of when you're drafting arbitration agreements according to the SIAC rules. I'm now going to move on from discussing the features to discussing how you can qualify your clients to apply for the to obtain the expedited procedure and conclude your arbitration in 6 months. So there are 3 criteria to take note of, which are either the dispute has to be under or equivalent to 6 million Singapore dollars in total, or parties have to both agree to go for the 6-month timeline, or there has to be some sort of exceptional urgency about your case that justifies deciding everything in 6 months. I'll go into these details in a bit more, but the first thing to take note of is that you have to apply for the expedited procedure before the arbitrators are appointed. As the procedure is generally that the arbitration begins with the notice of arbitration, generally parties choose to apply for the expedited procedure in the same notice of arbitration in which they start an arbitration. The other side has a right to respond, which is normally done within 14 days. So that's just a preliminary step. Then when you go to the first criteria, which is the aggregate amount of the dispute, it's important to note that this aggregate amount is not just of your client's claim, but potentially of the respondent's counterclaim and any set-off amount. All of that is added together, and if all of that together is, say, 7 million, then automatically you can't qualify for the expedited procedure. Having said that, if the claim is under 6 million, generally speaking, the president of the SIAC court will allow the application, albeit while considering the views of the other party as well. Moving on to criterion B under the rules, parties can agree on the expedited procedure either in the original arbitration agreement or subsequently. And please take note that the SIAC actually has a model clause if you want to put it into your agreement to begin with, which we've put into the slides for you there. The third criterion is cases of exceptional urgency. This one is less sure. This is a sort of case-by-case basis. We put up 2 instances there for you to get a sense of how it's decided. The first was that the dispute was about one party paying the other, the respondent paying the claimant. And because the respondent was not paying the claimant couldn't pay a third party under separate obligations, which had a substantially higher value than the dispute. So because of those factors, it was decided that this was a case of exceptional urgency because it could lead to losses for the claimant that were far beyond the dispute in question. And the second general sort of category is dissipation of assets. So wherever there's a risk that there'll be a dissipation of assets, it's similar to sort of non-court proceedings. If you can show evidence of that, that could potentially be a ground for exceptional urgency and therefore expedited procedure. So now that I've taken you through the criteria, that's not the end of it. So once you have made out one of these criteria, you still then have, it's likely that you will get the expedited procedure, but the registrar still has the discretion to look at the views of the other party and to also look at the entire case and all the aspects of the case before it confirms that the arbitration will be expedited. So we have some experience about how the registrar treats some of these reasons for not allowing the expedited procedure, even if the dispute is under 6 million Singapore dollars. So to take you through those, the first one is sort of a general one, which is that the registrar will look at the overall case, will look at the claims, look at how many witnesses are involved, how detailed the facts are, and take that into account. So obviously, the simpler the case, maybe a simple breach of contract with a few key documents, the registrar will be more likely to speed up the arbitration. A second one is a sort of general reason, which is because international arbitration is conducted in many the parties are from different jurisdictions, as are the subject matter of the dispute. They will look at the sort of jurisdictions in which the parties are, consider if there's any impact on the witnesses, any evidentiary impact, and that's something they will consider as well. However, that said, there were 2 factors that came up recently in an expedited procedure arbitration that we're currently conducting. The other side first raised the point that COVID-19 had made it harder for them to take instructions from their clients, especially in the 6-month time frame. And secondly, had meant that a physical hearing was harder. This was rejected. The registrar did not give his reasons, but we can assume that one reason would have been video link. You know, we're even doing this webinar by video link. So it can't be said that you can't take instructions given what has happened for the last 6 months. The second reason could be because there is a flexibility for the tribunal to extend the timelines. So if for some reason something comes up and witnesses cannot make it for a physical hearing, the tribunal can maybe extend by 2 weeks, 3 weeks before deciding whether there needs to be before deciding whether a hearing can't take place. The tribunal can also, of course, decide earlier on whether documents, as I was saying, whether the dispute can be decided on documents alone and doesn't need a hearing. The second reason that the other side raised was that the expedited procedure removes the option for parties to challenge the tribunal's jurisdiction as a preliminary step. This basically means that under the SIAC rules, generally, you can decide, if you want to object to the jurisdiction of the tribunal, for whatever reason, say that you had appointed a different arbitrator in your agreement, or whatever the reason is, you can decide that at the beginning of the arbitration. And if it's in your favor, then everything stops. And so everyone saves their time and costs. Moreover, if it goes against you, you can appeal within 30 days to the Singapore High Court to review the decision. So their argument was that under the 6-month time frame, this appeal process of 30 days, and let's say 14 days for the initial decision by the tribunal, cannot be accommodated because it's too tight. Again, this was rejected. And again, our suspicion is that the tribunal just figured that it can lengthen the timelines if necessary, and accommodate deciding about its jurisdiction before going on with the arbitration, even under the 6-month time frame. So that's that part. And my colleague, Ms. Yahya, will now take you through considerations of fairness in such a sped up procedure.
Hi, everyone. So you would have heard from my colleague that a key feature of expedited arbitration is that you will get your relief within 6 months. So what that would normally mean is that your arbitrations conducted under the EP route will involve imposing shortened timelines on proceedings. So to ensure that both parties are given sufficient opportunity to fully present their case, tribunals would typically take steps to ensure that their timelines set are reasonable and fair. So what I'll do now is to show you some sample timelines for an expedited procedure arbitration. You will notice that these timelines are far shorter than what you would get in a usual arbitration. So the first step is a first case management conference. So what happens is once the registrar determines that this case will go under the expedited procedure route, the tribunal will immediately call for a preliminary meeting. So prior to this meeting, the tribunal will then ask parties to work together and come up with proposed timelines for the conduct of the arbitration so that we can all meet the 6-month timeline. And the tribunal will also ask parties to consider whether or not an arbitration hearing is needed or whether the arbitration can proceed on a documents-only basis. So this is where you, or us rather, and our opposing counsel would work together to see where we can shorten timelines and whether there are certain steps in the usual arbitration process that we can drop, all in the name of ensuring that each party gets sufficient opportunity to fully present their case. And once parties come to an agreement, the tribunal is very likely to go with parties' agreement, and everyone is happy. So I'm going to go deeper into these example timelines that we see on the screen. We have talked about the first case management conference. The next 4 steps relate to the pleading stage. Now, in a usual arbitration, what you usually get is pleadings would be completed within about 2 or 3 months. And in an expedited procedure arbitration, parties will try to complete the pleadings within 1 month. And if possible, parties can also drop the last 2 steps, which is the reply and the rejoinder, if it is not necessary. Next slide. Okay, what you see on this slide, the first 3 points, these are the steps that are typically taken in the discovery stage of the arbitration proceeding. And usually the discovery stage will last about 2 months. And this is a very compressed discovery timeline. In Singapore, we use this thing called the Redfern schedule, where there is a standard format, and you make your document request using that standard format. You will then pass it to your opposing counsel for them to consider whether they want to object to your request or to agree to it. Now, if they object to the request, the tribunal will then make a decision as to whether or not that document should be produced. So as I said, this is a process that actually can be quite tedious, and it can take 2 or 3 months. But in a expedited procedure application arbitration, parties will work together to make sure this is compressed to about 1 month or even a few weeks if there are not a lot of documents involved. The next step would be witness statements. You would typically get another month to do that. Then you go on to a hearing if you decide that a hearing is even necessary in the first place, and the final award will then be rendered at the 6-month mark. So I go on to the next section. The question that would be on your minds, I think, will be what happens if the arbitration cannot be completed within 6 months? So to put it simply, 2 things can happen, and I believe my colleague Hamza has spoken about it. So the first thing that can happen is that the 6 months timeline can be extended by the registrar, but the registrar will only do this if there are exceptional circumstances. And the other thing that can happen is that the tribunal can also order that the proceedings no longer be conducted with the expedited procedure. Now, what is the difference between option number 1 and option number 2? So I think quite simply, under option number 1, the parties will still be bound by a timeline. And under option number 2, the parties are no longer bound by any timeline. So if you are a party that's looking to get relief as soon as possible, what you will want to argue is for option number 1. But of course, if the case suddenly appears to be unusually complex and the tribunal takes the view that maybe this arbitration can only be completed within a year or after 1 year, the tribunal would, in those circumstances, rather order that the arbitration be conducted in accordance with the normal procedure as opposed to the expedited procedure. Because I think it would be a bit funny to say that a 1-year arbitration is concluded under the expedited procedure route. So I will now talk about practical ways to make sure that your arbitration is concluded within a 6-month time frame. So I've spoken about this already. The first thing you might want to think of are what are some steps in the usual arbitration procedure that you can drop or dispense with. And the main thing is whether or not you need the arbitration hearing or whether you can drop that step. Because if you drop the arbitration hearing, your proceedings will be considerably shortened. But of course, there are some strategic considerations that you need to think of when you decide whether or not to dispense with an arbitration hearing. See, the thing about a documents-only arbitration is that you don't have the opportunity to cross-examine the witness on his witness statement. So you don't actually get the opportunity to test his evidence and destroy his credibility if necessary. So a documents-only arbitration will not be appropriate if the dispute turns on the bare assertion of a witness about what had happened and where there are no supporting documents and nothing written. So in that kind of situation, you might want to opt for a proper arbitration hearing so that you can fully cross-examine the witness. Another method is to limit the scope of the witness and the expert evidence. What the tribunal can do is to identify the issues on which it requires evidence to decide the dispute. And the tribunal can also ask the experts, if there are experts required for the dispute, to meet beforehand to prepare their reports and ensure that their witness statements are focused on the disputed issues. The last one is the chess clock method. This is just a procedure to ensure that the amount of time that each party has during the proceeding is strictly prescribed in advance. So the last point that we will make is really the question of whether should you or should you not go for the expedited procedure. And there are some things that you need to think of. So clearly, we have spoken a lot about how expedited procedure is an option that will help you save time and also legal costs. And it is also very useful for proceedings which are time sensitive. We have some clients who has come to us because their buyer has refused to pay on outstanding invoices. The buyer may be going bankrupt. So in that situation, expedited procedure is very useful because they can then get their award quickly and enforce it before anything happens to the buyer's company. But if your dispute is overly complex or technical, the short time frame can make it difficult for you to fully present your case, and that might jeopardize you. And another consideration you might have to think of is availability of legal counsel. I don't think this is so much of a problem in Singapore, but in some jurisdictions, it may be difficult to get legal counsel or retain legal counsel on a full-time basis at such short notice. So this is one thing that you have to think about as well. With that, we have come to the end of our presentation, and we would be happy to hear from you if you have any questions or clarifications for us.